of the provisions of the contract and performance in accordance with those provisions, it often matters little what law is applicable, since, it is fair to say, interpretation of contracts to effectuate the intentions of the parties is a fundamental principle of the law of contract interpretation in the law of all nations. Courts in the United States provide provisional remedies such as attachments and injunctions, often only in exceptional cases. Outside the United States, however, there is generally no bar to parties obtaining an attachment of assets belonging to a defendant as security for an award expected to be rendered in the future. Such attachments are frequently available of assets in one country to secure arbitral awards expected to be rendered in another country. Much of what one may do or not do in presenting a case in international arbitration depends on the particular dynamics of the particular case. These may manifest themselves in agreements between the parties, with or without the aid of the arbitrators, under which the schedule of the presentation of detailed briefs with exhibits is agreed on following or not after discovery, and thereafter an evidentiary hearing followed by, possibly, post-hearing briefs and post-hearing oral arguments. Since it is the chairperson of the arbitral panel that determines the procedures to be followed, sometimes even over the opposition of counsel for both parties, it is important for arbitration counsel to be aware of the likely predilections of civil law, as opposed to common law, arbitrators. Arbitration is final and binding, and under the New York Convention, it is exceedingly difficult to set aside an arbitration award. Awards in international arbitration are almost always reasoned in the sense that they contain not only an award of damages or the dismissal of the case, but also the reasons for the arbitrators taking the action they did. International arbitral awards are often unanimous, and it is not an unfair inference that such awards represent, at least in cases where a clear victory for either side is not mandated by the facts, that there has been a certain amount of negotiation among the arbitrators over the amount of the award. In conclusion, from the time of desert caravans to today's disputes regarding intellectual property and cutting-edge technologies, this age-old expeditious alternative, which we call arbitration, that advances free enterprise and freedom of contract, has evolved and gained worldwide acceptance and application. Noting our proud past and anticipating our promising future, I am certain the international arbitration venues of the world will duly accept the challenges of exponential growth that the coming age of international commercial arbitration will offer us. As vanguards then, now, and into the future, we should celebrate in unison this acknowledgement of our collective hard work and its resultant acceptance of commercial arbitration, not only as a resolution to conflict, but exactly as our founders had dreamt, an advancement of goodwill, good faith, confidence, and cooperation through world trade relations.
Thank you, Mr. Slate. Let us begin now with our second question and answer session. We have a call from la Comisión Federal de Electricidad en el Auditorio Atoyac en el Distrito Federal, México.
Gracias. Buenos días.
What is the additional cost that you would say in a percentage-wise for an organization to use arbitration methods, and what would be the what you would be gaining? What would you gain with that?
Mr. Slate?
Well, the cost for the use of arbitration, as contrasted with traditional litigation, we estimate generally to be at least 40% to 60% less than traditional litigation costs. And what one gains is a degree, not only the degrees of certainty that we talked about with respect to designing the process, but one can also include in the arbitral design the details of how long the arbitration will take. That is one element that is open to both discussion and to definition. That is to say, the parties may agree this matter should take no more than 3 days. And in that way, one also controls the costs. So, yes, in the U.S., the use of the courts is without charge. However, the cost of litigation, the transaction cost, is very significant.
Thank you. We have a call now from la Universidad Autónoma de Baja California Sur en La Paz, Baja California Sur.
Sí, buenos días.
Good morning.
La pregunta es
The question
si
is
en un contrato
whether or not in a contract, in a commercial contract, the parties omit the arbitration clause provision. What is the validity, the judicial, the legal validity of this contract, and does one of the parties can they have the certainty that they will be served by any one of these agencies, arbitration agencies and mediation agencies?
Mr. Haigh, did you hear that question?
I think I understand the question. If there's no arbitration clause in an agreement, that doesn't stop the parties, if they wish to, voluntarily agreeing after the dispute has arisen to submit the matter to arbitration. That, in fact, often does occur. That doesn't affect the validity of the agreement itself. If I've understood the question, that would be my answer to it.
Mr. Slate?
And if I agree with that, and if I might add, the second part of the question was how does one ensure that they'll have the services of a given institution? And I would say simply that the pre-dispute agreement typically names not only the process and describes the process, but may also include the name of the entity that they wish to use. However, I would add that if, for example, a given entity is written into the clause, and at the time a dispute arises, both parties agree, yes, we want to use arbitration, but for reasons of their own knowing, they'd prefer to use another entity, then that is also possible. Again, the beauty of this entire process is that it is very much about party choice.
Thank you. We have a call from el Instituto Universidad Empresa, la Universidad Blas Pascal, Córdoba, Argentina.
Buenos días.
Good morning.
Quisiéramos conocer cuál es la
We would like to know what the attitude of the firms is when it comes to incorporating some provisions in the contract that would force the parties to resort to arbitration and mediation in the business environment.
Mr. Slate?
Well, increasingly, it is very, very positive, and this for the reasons that we have all discussed. But where it is open to discussion and debate, it is discussed and debated just like any other clause in the contract. And so if the parties think that they would like to use alternative dispute resolution and they've never engaged in it before in an international transaction, well, one suggestion would be that the parties may write into the contract the agreement to first try mediation, and if that is unsuccessful, to go to binding and final arbitration. We haven't talked a great deal about using these dispute resolution methodologies in concert with one another, but as we say in the U.S., sometimes parties are willing to put their toe in the water to try the process in the first instance. by the use of mediation.
Let me just, thanks, Bill. And I would just add this. I think it's natural that business people go into their business dealings or commercial relationships with one another expecting that they're not going to really have problems. Everybody hopes at the beginning of the relationship that things are going to work out. And so sometimes not a lot of attention is given to what will happen if they do have a dispute. And I think over time, parties become more sophisticated about that. They only need to have one bad experience, and they've been educated for the rest of their lives about the need to give some attention to this. And I believe, as Bill has said, that more and more frequently now, this has become a positive aspect of negotiations between commercial parties, where they see that there is a real advantage in having a quick and cost-effective and reliable way of getting through their differences and being able to continue the relationship so that they can go on doing business together, notwithstanding that they've had some disagreement along the way.
Thank you. Our next question is from La Universidad Privada Boliviana, Cochabamba, Bolivia.
Good afternoon. The question is the following. What is the difference from the point of view of semantics and legal between an arbitrator and an expert? Or is it that their powers in their respective fields are similar? What is the difference, or compare and contrast?
Mr. Slate?
Yes, thank you. In the sense that we engage arbitrators in the U.S., arbitrators are frequently experts in their given field. We had a question earlier about whether it's necessary for arbitrators to be attorneys. David said, and I agree, that most often that is true. However, even when arbitrators are attorneys, they typically have expertise in a given area of the law. And indeed, if they're not attorneys, if they're architects or engineers or other experts, they of course bring that expertise to the process. The main difference is, yes, an arbitrator may be an expert and probably is an expert, but he or she is also empowered through the process to make a decision that's binding on the parties.
Thank you very much. Now this will be our last question. It is coming in from La Universidad Tecnológica de Panamá, en la ciudad de Panamá, Panamá.
Good morning. Would the firms and businesses who are doing business in Cuba, would they be willing to use arbitration to resolve disputes and conflict? Does the Helms-Burton law allow for this, and what are the restrictions to this, should they want to resort to arbitration? Thank you.
Mr. Slate?
My understanding is, and I beg to be corrected if necessary, that Cuba is not a party to the conventions at the present time. However, through international treaty law, it is possible through other international treaties, it is possible to use arbitration. I'm advised presently of 4 international arbitrations going on with one international arbitrator right now in Cuba.
Okay. Thank you very much, Mr. Haigh and Mr. Slate. We hope that you have enjoyed participating in this video conference, and we hope that our viewers have enjoyed listening to your thoughtful presentations on arbitration and mediation. We hope that all of you will participate in the 3rd program of this series, scheduled for September 26th, and entitled Effective Management of International Conflict, the Strength of Diversity. For additional information on the International Training Center's programs, please consult your participants' manual, in which you will also find the dates and specific topics of this year's Strategies for Global Competitiveness series of programs. If you are interested in attending or participating in training sessions which will be offered by the International Training Center, please feel free to contact the Center by letter, phone, or fax. On behalf of all of us who collaborate with the International Training Center, I thank you for your participation and interest in today's programs. See you soon.